Worship. My name is Erica Welch, and I, together with my learned friend Mr. Milkovich, represent the appellant, Mr. Charles. My learned friends Mr. Birkenstock and Mrs. Price represent the respondents, Mr. Anthony and Mr. Bent. Does your worship require a summary of the facts?
Very brief one.
The respondent, Mr. Anthony, when he decided to sell his home, employed the other respondent, Mr. Bent, to provide a valuation, which he did, of £500,000. When our client, the appellant, purchased the house, after relying on the valuation, he realized the actual value was £300,000 and brought suit for negligence against Mr. Bent. I would like to refer your lordship to my skeleton argument in proceeding to the substance of the appeal.
Is that your button?
Yes. Thank you. With your lordship's permission, I would like to continue to my first submission. First, I submit that a duty of care can be established in these circumstances where there is no direct contact between the purchaser and the valuer. In the case of Caparo Industries, reported in the second volume of Official Law Reports, Appeal Cases for 1990, at page 640, paragraph C, Lord Oliver, quoting Lord Griffith, states that a duty of care arises when it is foreseeable that if advice is negligent, the recipient is likely to suffer damage, and also there's a sufficiently proximate relationship between the parties such that it is reasonable to impose this duty of care. I submit today that this standard holds true even in situations such as the case before us today, where there is no direct contact between the injured party and the negligent party. In Smith and Bush, reported in the first volume of Official Law Reports, Appeal Cases for 1990, at page 871, paragraphs B and C, Lord Jauncey asserts that a duty of care can still be established in these circumstances, provided there is still this sufficiently proximate relationship between the two parties, such that one can have a duty of care to the other. Thus, we submit that this duty of care can, in fact, be established in this situation between Mr. Bent and Mr. Charles.
Why, on the facts of this case, is it established in your submission?
I submit that because it was foreseeable at the point when Mr. Bent, as a professional valuer, provided a valuation of the house, indeed for the purpose of the house being sold, that it was foreseeable that a purchaser would then purchase that house and probably in all likelihood rely on his valuation in doing so.
Did the valuer, was he told that it was for the purpose of selling the house?
The facts do not state specifically that Mr. Anthony said this is for that purpose, but they do state that he had first decided to sell his house and then employed the valuer, who is a professional, and so we submit that he should have known in doing this evaluation for the purposes, or for an employer who was looking to sell his home.
Should have known or should have asked the question?
Perhaps, yes. Moving on to my next submission, that this first standard of duty of care is satisfied in this circumstance because Mr. Charles's damage was, in fact, as I mentioned, foreseeable to the valuer, creating a sufficiently proximate relationship, which is the prerequisite for a duty of care.
So are you saying that if it's foreseeable, they are sufficiently proximate? Or are they separate?
Yes, they are tied together. If it is foreseeable that this damage will occur, then that can create a sufficiently proximate relationship for a duty of care, provided that it is also just and reasonable to impose that duty of care. Now, Mr. Bent, as I mentioned, was called upon by Mr. Anthony because Mr. Anthony was looking to sell his home, and so the purpose of his work there was to assess the value for a sale. This would alert any reasonable professional, as Mr. Bent was, that there would be an individual who would purchase that home and foreseeably rely on the house's valuation report in deciding whether or not to buy or how much to buy. And in fact, Mr. Charles did and incurred substantial damage. While it is true that, unlike in many of the cases preceding this case, the negotiations did begin after the valuation occurred, This does not change the fact that the purchaser was still, as I mentioned, foreseeable at the time when we look at the purpose for which Mr. Bent was employed. In the cases upon which we rely, Smith and Bush, and also Merritt and Babb, where the surveyors or the valuers were assessing the home for mortgage security purposes. And so there was, the court ruled, a duty of care to the mortgagees. However, in Caparo, the accountants were assessing a company's assets for the company's own accounting purposes. And so they did not owe a duty of care to another company, but only because the purpose was completely separate from the other company's aim in doing a takeover that indeed this company wasn't even aware of. And so I submit that our case is more similar to the first two, Smith and Merritt, as I mentioned before, because of the purpose for which the valuation was being done.
Why doesn't Smith turn on the fact that there really was a direct connection between the purchaser and the valuer, in the sense that the building society that obtained the valuation was really doing it specifically for the purchaser? Why doesn't that distinguish the case from this case?
Yes, my lord. That would be a distinguishing fact, but we still submit that this case, it is completely, not completely, but it is rather different from any case that we have relied on, purely because there was actually no contact. But given the submissions that the judges in these previous cases have given, we believe that there still can be a connection solely based on the foreseeability.
But Bent didn't know what the valuation was being used for, did he?
We submit that he should have known, if he didn't know, that as a professional who has been employed in this business, that he would know, being called by Mr. Anthony, who the facts tell us was intending to sell his home, that he either knew or should have known that this was being used for sale purposes, and that he would make that inference that there would be a purchaser because he was conducting a sale.
Is that what the test really is, though, isn't it? You should know what the purpose is, and then it be reasonably foreseeable within that a particular class of individual might rely on the knowledge, rather than it being reasonably foreseeable, the purpose of the valuation be reasonably foreseeable. I think they're different.
They are different, and both important, and I submit are both present in this case. We believe that while the facts don't explicitly state that he knew the purpose of the valuation, because he was being employed by Mr. Anthony, who had decided to sell his home, and that was the reason why he had contacted him, that he probably didn't know.
We don't know that. He could have obtained the valuation for any number of reasons. Insurance, just seeing what his house is worth as a speculative step.
Yeah, I would concede that that is true, and that if he really was unaware of the purpose for which he was providing this valuation, then it might not be foreseeable that there would be a purchaser. But in this case, based on his professional experience and given the facts, we believe that a purchaser was foreseeable.
What about the third limb of the test, counsel, that it need be both foreseeable and proximate, and on top of that, fair, just and reasonable? Is it fair, just and reasonable in circumstances such as this to create liability when there's never any real relationship between the two?
Yes, my lady. We submit that it is both just and reasonable. The court has also looked to the relationship between the parties in deciding whether public policy and justice would warrant a duty of care in this situation. In Smith and Bush, at page 851, paragraph E, Lord Templeman actually notes that in this case, the valuer would be more willing to accept liability from the building society, which in this case is the entity which is seeking to give the mortgage, so essentially the seller. He would be more willing to take on liability from the seller than he would be to the purchaser, because it is the purchaser who is vulnerable. Now that's the exact same statement is still true here. Mr. Charles was also in a more vulnerable position compared to either Mr. Bent or Mr. Anthony, and failing to hold Mr. Bent accountable to both the seller and the buyer actually poses serious ramifications for public policy. If the valuer indeed is only subject to duty of care to the seller, as the valuer rather would probably prefer, according to Lord Templeman, there is little to prevent them from overvaluing houses, as happened in this case. because the seller likely wouldn't find this to be a breach of their duty of care, because indeed they're the ones who are benefiting monetarily from this transaction if their houses are being overvalued. Whereas if there's no duty of care owed to the buyer, they have no protection in this scenario. I see that I am out of time.
Thank you very much, Council.
My name is Chelsea Price, and as my learned co-counsel has stated, I will be talking about the second area of the appeal, which is the appellant's loss was due to his own impecuniosity and contributory negligence. Therefore, the first issue is impecuniosity. The respondent should not be liable for the losses which resulted from the appellant's impecuniosity. Both foreseeability and reasonableness need to be considered when discussing impecuniosity. There are 2 points regarding foreseeability. The first point about foreseeability concerns remoteness. Although the appellant's counsel has stated more recent decisions from lower courts that distinguish themselves from the rule in Leisbosch, we state this rule should be upheld because it should be the controlling rule as it was issued by the Lordship's House. I submit that as Lord Wright stated in Leisbosch v. Edison on page 460, the respondent should not be liable for losses that arose from the appellant's impecuniosity because the losses were too remote and therefore were not traceable to the respondent's acts and were outside the legal purview of the consequences of these acts.
But that was a case where there were some damages assessed. They just weren't assessed to the extent that the plaintiff was claiming, correct?
Exactly, yes.
So would you then concede that with respect to impecuniosity, it only goes to the amount of the damages and not to the issue of liability?
Okay, so in response to your question, my lord, I would submit that in Leisbosch, the court held that any loss which the plaintiff sustained through being hindered in performance of their contract with harbor commissioners specifically was too remote and therefore could not be recovered. So you're correct in stating that some damages were recovered, and therefore here we submit that any loss which came out of impecuniosity specifically was too remote and should not be recovered.
Does that mean, though, that you then concede there is, that doesn't affect liability, that impecuniosity doesn't go to the question of whether there's liability?
Your Lord, it would go to the question of whether there was liability because liability establishes damages. Right. And the second point about foreseeability concerns reasonable foreseeability. On page 381 of Alcoa versus Broderick, the court states, where a loss is contributed to or is consequent upon impecuniosity, it will be recoverable if the loss is reasonably foreseeable. The appellant's counsel cited a quote. It's in tab 15, and it's in the case of Alcoa v. Broderick at page 382, verse 383, that states, it was obviously foreseeable that if the house of a person in the position of a plaintiff was seriously damaged, he would not or might not have the wherewithal to repair it, and that his ability to do so would depend on his establishing the liability of and recovering damages from the defendant. And we submit that Alcoa is distinguishable from the present case because in Alcoa, it was reasonably foreseeable that the plaintiff's impecuniosity would arise from his home getting severely damaged, not once but twice. Whereas here, it was reasonably foreseeable that damages would arise as a result of the appellant's impecuniosity. It was not reasonably foreseeable, in other words, it was not reasonably foreseeable when following the chain of events that our client, the respondent, would know that the appellant didn't have money when purchasing a house for this much money, and therefore couldn't afford a valuation, and therefore would rely on our valuation or his valuation, and therefore that the loss would be suffered. Regarding reasonableness, on page 442 of Dodd v. Canterbury in tab 16, the court states it was the appellant's duty to do all that was reasonably possible to mitigate the loss, and that if through his lack of funds he was unable to incur the necessary expense of such remedial measures, the defenders ought to not suffer for it. Therefore,
Councillor, sorry, can I interrupt? It could be said on one view that his impecuniousness was caused by you indirectly. How would that affect your submissions?
exactly.
And do you accept that it was caused by you firstly, and how would it affect your submissions?
Yeah, my lady, we do not accept that it was caused by us, and it would, I guess, we did not know, my client did not know that the purchaser was relying on us at all, or him at all, according to the fact pattern.
Even if you hadn't known it, if he's impecunious because of something you've done, forcing him to up his offer to the point where he has no money for evaluation, is it right that you should get away scot-free, so to speak? Does the law allow that?
My lady, I would not draw that close of an inference between the price that he paid or was forced to pay and the value that we provided, or that my client provided. I think those issues should be considered separately.
Why?
Well, you have the price because of your valuation.
Right.
Okay.
So assuming you've lost on liability,
Exactly.
and is that, so why else would he have upped his price other than by relying on your valuation and without
You're
having a price?
correct. He did up his valuation based on what we provided or what my client provided. So sorry, will you restate your question, please?
So, I suppose, taking into account the general rule, is it different where the impecuniosity of the appellant has been caused by the respondent?
Oh, I see. Yes, my lady, I would submit that it is different, where the impecuniosity has been caused by that. It's stated in Alcoa v. Broderick, which I stated previously, where loss is contributed to or is the consequent upon impecuniosity, it will be recoverable if the loss was reasonably foreseeable. So therefore, I submit, since the loss was not reasonably foreseeable, it would not, we should not be liable for that, or responsible for that. Am I answering your question?
I understand what you're saying, yeah.
Okay, so back to the point of reasonableness. Therefore, as a result of the holding in Dodd versus Canterbury, it is submitted that it would have been reasonable for the appellant to receive his own valuation in an effort to mitigate the loss. Regarding contributory negligence, the respondent should not be liable for the losses which resulted from the appellant's contributory negligence. In Yanni versus Evans, which is cited on page 1182 of Merritt versus Babb, in which the plaintiff the court quoted a case, Yanni versus Evans, in which the plaintiff relied on a faulty valuation provided by a valuation firm to the defendant, who was a building society.
Counsel, help me with discomfort that I have. I have discomfort that arguing contributory negligence when the solicitor suggested that the appellant get his own valuation is a very neat, easy argument to make. The fact remains that your client grossly misvalued the property, grossly misvalued it. And that leaves me with discomfort that the contributory negligence argument is just too easy in these circumstances. Help me get over that discomfort.
Your Honor, I would submit that if we follow the chain of causation, which is stated in County Personnel versus Pulver, where the defendants made arguments that it was the negligence resulting from the plaintiff's actions following the defendant's alleged negligence, damage should not flow from the defendant's negligence. Here it is submitted the appellant was negligent in not obtaining his own property valuation, following the respondent's alleged negligence, providing a faulty valuation, and thus the chain of causation between the alleged negligence by the respondent and the damages suffered by the appellant is broken. So I submit that it is an easy question and that there was contributory negligence because the valuation or the appellant should have received his own valuation.
But why would he assume that the valuation that was given to him by the seller was so grossly off? He wouldn't. He would assume that it's accurate.
I think in some circumstances that is appropriate, but oftentimes it isn't uncommon to find a seller give evaluation and a buyer give evaluation, them to be totally different, and then for them to settle somewhere in the middle. It's similar to eminent domain where everyone gets their own valuation and then they settle at one in between. You wouldn't rely solely on the state's valuation because it's always lower.
Can I ask, your opponent made some submissions about quantum. What would you say about quantum?
About quantum damages?
Yeah, about how much. How much? Let's say you lose. How much are they owed?
Yes, my lady, I would agree.
If you just want to answer that question, and
Okay.
stop.
Okay, thank you. I would agree that the compensatory damages, as they alleged, at $180,000, which is the difference between what was paid and what was received in terms of the house, would put the position in a place as if that he'd never seen the valuation. The appellant had never seen the valuation.
Counsel?
Thank you so much.
My lords, I will address the issue regarding Charles's contributory negligence and impecuniosity. I submit that the dismissal from Queen's Bench Division based on Charles's contributory negligence and impecuniosity was improper and should be reversed. First, it is conceded that Lord Wright established as a general rule that a defendant should not be liable for losses resulting from a plaintiff's impecuniosity. This rule was derived from Lebosch, Drudger Lebosch versus Steamship Edison. And while we do concede that that is the general rule, it is noted in that case that there are a lot of qualifications and exceptions to that rule. And as I'll discuss later in my argument, Alcoa Minerals of Jamaica Incorporated versus Herbert Broderick will distinguish that and will be more applicable to the case, the instant case.
Counsel, I want to take you
yes.
to the other point, because to me, I'm trying to understand why it's not a slam dunk against you. It's the solicitor advised your client to get an independent valuation. Your client chose not to do that. Why isn't that game over?
So, the reason why that would not be game over, my lord, is that according to Merritt versus Babb, there's a the rule from that case says the defendant cannot successfully assert a contributory negligence defense against the plaintiff because the plaintiff failed to have an independent survey or take other steps and relied on defendant's negligent evaluation. And so the reason why that wouldn't be able to be applicable here is because just because he was not able to get his independent evaluation on his own, first of all, was due to he didn't have funds. He had a want of means, and the fact that he
had a lot of means. He paid almost £500,000.
Yes, I do concede that point. However, I would argue that just because he was able to purchase the home doesn't necessarily mean that he can, at the time, have the means to get an evaluation.
Could he have decided just to pay a few £1,000s less for the house, or offer a few £1,000s less and use that extra money for
Could who? Sorry,
the buyer?
oh yeah. It
Could have just offered a slightly lower amount.
Could have offered a slightly
So
lower.
your client, instead of paying $480,000, could have, for example, offered $475,000, saved £5,000 for valuation.
Yes, I do concede that point. That is very possible. But I do think the main crux of this argument has to do with the plaintiff's impecuniosity. I think it's weighted more in his favor. And for example, in Alcoa Minerals of Jamaica Incorporated versus Herbert Broderick, there is no absolute rule, or it was held in that case, there is no absolute rule that damages due to the impecuniosity of the party are too remote. So just to say that Charles was not able to have the funds to get a valuation on the home, that is not something that would be too remote for him to do. And also in Alcoa, there's the test that comes out from this is a reasonable foreseeability test, and it's on page 371G of the case, and they held that it was foreseeable that if the house of a person in the position of the plaintiff was seriously damaged, he would not or might not have the wherewithal to repair it, and his ability to do so would depend on his establishing the liability of and recovering damages from the defendant, and consequently the increased cost of repairing was not too remote. And so the reasonable foreseeability test applied in that case could also be applied to our case as well, because could it be reasonably foreseeable that Charles would be able to not have enough funds to get his own valuation, and then still negligently, or rely on a negligent valuation, and I would submit that is very reasonably foreseeable.
I'm a little just confused how your analysis is separated between contributory negligence and impecuniosity. So can you just set out for me in a couple of sentences how you see both of those separate issues?
Yes. So, sorry for the confusion, but
it's not your fault. It's meant to be
Yes.
confusing, but
so with regards to the impecuniosity, has more to do with the mitigation of damages that Charles had a duty to do, and the contributory negligence has more to do with the means as far as the damages.
Well, mitigation of damages is what you do after damage has already happened
Yeah.
to mitigate it, to make it less.
Yes.
Is that really what this is about? What could he have done after the loss to make it less? Isn't this more about preventing the tort from happening in the first place, or preventing the loss?
Yes. This does have to do more with having to prevent the loss. And in his case, or in Charles's case, he was not able to prevent the loss because he didn't have the funds to do so. And
Because all of the cases that you cite are to do with mitigating the loss after the event, whereas this impecuniosity is before the event, if you like. What do you say the effect of that is, that affect your submission?
I would submit that I'm sorry, can you rephrase the question?
Yeah, so the cases deal with what happens when the tort's already happened and the affected party doesn't have enough money to mitigate the loss. So for example, I flood the roof in this building, but there isn't enough money to stop it all crashing in or whatever. Okay, so then the question becomes, how much damages should I pay? But this is more to do, the impecuniosity here happened before the wrong even took place, and you might even say was part and parcel of the wrong somehow. So does that, how does that affect the general rule that you've set out, or does it not?
As I stated before, I just think that the general rule that a defendant shouldn't be liable for those losses when there is impecuniosity on the part of the plaintiff is kind of, Alcoa is a more recent case that kind of distinguishes from that and overrules that in a way, because like I mentioned before, that it says there's no absolute rule that damages due to the impecuniosity of a party are too remote.
Right, so another question. Let's say we find in your favour on everything. What quantum? So talk to me about quantum. How much money do you think you are owed in damages?
I would say that you would have to. It would have to be £180,000, because ultimately that is what he paid for it, and it should be compensatory damages would be adequate in this situation in that it would make the plaintiff whole. He expected a well put together house that's not seriously damaged, whereas that's not what he received, so it would be the difference in the total value of that and what he actually ended up paying for it.
What's the principle underlying damages, compensatory damages for a tort?
Sorry.
What's the underlying principle?
The underlying principle for compensatory damages to make the plaintiff whole.
You put them in the position as if the tort had never been
Yes.
committed.
Yeah. Okay.
So on applying that reasoning here, what would have happened if the valuation had never been seen by the buyer?
Well, then he wouldn't have paid for the house.
He wouldn't have upped his price.
Oh yeah. Yes.
So what was he going to pay before?
He was going to pay. Sorry, 1 moment. $500. $480.
That's what he did pay. What was he going to pay before the valuation?
$500,000. Sorry.
It's okay. It's,
Yeah.
it's just a.
Yeah.
It's fine.
Sorry, I don't have that in front of me right now.
No, that's absolutely fine.
I see my time has elapsed.
Thank you, counsel.
May it please your lordship, as stated by my learned friend, I shall be responding to the first ground of appeal. Before I address the first point listed within the skeleton argument, would the court prefer a brief summary of the facts?
No, thank you.
Yes, my lord. In proceeding to the substance of the appeal, I submit that there was no duty of care owed to the respondent, Bent, to the ultimate purchaser, Charles. In substantiating the submission, I have 8 supplemental points. My first point, my lords, is that in the case Smith and Bush reported in the first volume of the official law reports, appeal cases for 1990 at page 835, section G, or tab 1 in the binder in front of my lords. There are 2 ways in which a duty of care should arise, 2 traditional ways, that is. The first one being that there was a statutory obligation, and the second being that there was an express assumption of responsibility. In the instant case, there was no stated statutory responsibility, and secondly, there was no express assumption of responsibility. However, on page 836 or tab 2 in the binder, there can be an inferred voluntary assumption of responsibility. And as it states on page 835, in order for that implied assumption of responsibility, when there is no direct contact between the persons, it is possible when it's sufficiently proximate. However, in an instant case, I submit that it is neither proximate nor reasonable. As to my second submission, in the case Capara Industries and Dickman reported in the second volume of the official law reports, appeal cases for 1990 at page 610, sections B through C, or tab 8, there is a useful test for duty of care that is provided. That test is that first, it must be foreseeable. Second, there must be sufficient proximity between the parties involved. And third, it must be just and reasonable to impose liability. In regards to the first element of foreseeability, in both the cases Smith and Bush, which is under tab 6 at page 865, and the case Merritt and Babb, which was reported in the Queen's Bench appeal cases for 1990 at page 865, section B, that's actually the Queen's Bench Law Reports for 2001 at page 1183, which is tab 12, section G. It is submitted that it is not foreseeable to evaluate a subsequent purchaser would rely upon his valuation when he was paid by the seller, as it was in the instant case. He had no contact with the purchaser, and he only communicated with the seller, and the facts provided don't state that the seller informed him that he was selling.
But he's a professional. Why wouldn't it be foreseeable that a purchaser downstream would rely on a valuation provided to a seller?
Yes, my lord. While it would be commonplace for such valuations to take place for a sale, there are myriad reasons why valuations of homes are done. Tax purposes, for estate planning, just for general knowledge of your assets. All these are reasons why, and with the facts provided, we are unsure as to whether he was informed. And even so, the type of property that we're dealing with, which comes later in my presentation, we're talking about a 300,000 to 500,000 pound residence in Kensington, which is one of the most desirable neighborhoods in all of London. So it we submit that it would be reasonable for council or for the valuer to assume that if it was being purchased, a secondary valuation will be done on their behalf, and in fact, the solicitor suggested that he do just that.
Why isn't the burden on, I mean, certainly one very common reason why a valuation is provided is for the sale of a home, sale of the property. Why, the only reason, as far as I can tell, that the valuer didn't know that the home was gonna be purchased is because he didn't ask the question. Why shouldn't that burden be put on the professional to ask the question?
Yes, my lord, while it is understandable that professional does owe a duty when they provide a professional valuation, such as in the instant case, we submit that there are sufficient public policy reasons, such as the fact that if a liability is placed upon a valuer to hold a valuation out for any purpose to any person, then their cost of insurance will go dramatically up because of the increased liability.
We're
Furthermore,
not talking about the whole world.
Yeah, well, not exactly the same question. This isn't anybody and any purpose, simply isn't a buyer of a house that's just been valued pretty foreseeable, pretty proximate, no real reason not to create a duty.
I submit that, yes, while it is not the whole world, to our valuer, it quite literally could be. We're talking about if, say for instance, somebody decides to take out a loan against the home and the homeowner allows it from Dubai. Now, is he reliable to him because he used the valuation without informing him?
Well, we
Does
don't
he go anywhere?
necessarily need to discuss all the possible uses that might have been made of this valuation, but what we have here
Yes,
is a
ma'am.
home that was valued ostensibly so that it could be sold, and a buyer relying on it. Isn't that pretty proximate?
Yes, my lady. I submit that if we narrow the scope to that limit, it would not seem as proximate, but in light of these public policy reasons as well as the other reason that will be presented in my presentation, I believe that he is not liable for that duty of care.
Well, let's think about public policy then, since
Yes.
you mentioned it. What's wrong with imposing a duty on any professional to do their job properly? That's the end result that imposing a duty here will have.
Yes, my lord.
Why
Well,
is that a bad thing?
while it is always desirable that the public have a confidence in every profession that it uses, I would submit that if we make them liable for many reasons, as stated earlier, that their liability is going to be dramatically increased, which in turn increases the amount of insurance that they must
Only
pay.
if they're negligent. So all
Only
it
if
is
they're
is
negligent.
negligent.
Indeed. While it is true that only if they're negligent, the cost of insurance remains the same even if they have no claim. While it will increase if they have additional claims, then yes, my lord, you're correct. However, I would say that if that increase insurance must be paid, then the increase of the amount for our valuation will go dramatically higher. Furthermore,
Couldn't you say that's about more or less anything? If we just get rid of liability generally, then no one needs insurance.
yes, my lady, you would say that.
And isn't the reason we impose liability because there's some kind of benefit to society from it?
Yes, I think that's the balancing test. I think that there must be a certain amount of liability that is given and some that is not, and we submit that to extend liability to such an extent as the court has questioned here would be too far in one way. It would tip the scale unfairly. One moment. In regards to the second element of proximity, we do submit that there was an opportunity for intervention, and that in the cases in front of the
What do you mean
court,
by opportunity for
there was an opportunity for intervention. Essentially what I'm saying is that the purchaser did have the opportunity to have his own valuation done, and there was sufficient time, and with the type of property we're talking about and the purchase price of it, one would say that it could be assumed that they would be able to afford such a valuation, and by opting to go against their solicitor's advice to
I think we're merging into contributory
yes,
negligence.
my lord, yeah, as I was about to say,
Steve,
my
the
learned
concept.
friend will be discussing it fully. That is the extent of that.
So we've got this three-stage test with these
Yes.
three-prong test.
Mm-hmm.
You only need to knock one of those grounds out to
Yes.
scupper the other side's case. So what's your strongest case?
My strongest case, my lord, would be for foreseeability.
Why?
Foreseeability because based on the limited fact pattern we received, we simply do not know that our valuer was aware that it was for the sale of the home.
So you think knowledge of the sale of the home is crucial?
Yes, and supplemental to that, even if actual knowledge is not known, the type of property that we are dealing with doesn't suggest that it would be relied upon. The type and price and location and
Okay.
everything else involved with it.
Okay.
Furthermore, there is a 3-part test under proximity, and that is that in order for something to be proximate, it must be directly intended, so the plaintiff must have directly intended the person, which would be the purchaser, to rely upon her statement. Secondly, there must be a specific transaction that the maker knows is occurring, which we say he did not know. And thirdly, the purpose for which the statement was made, so that was for sale. And while
Why
there's
wouldn't that be your strongest point then, if it's got 3 elements itself? Why wouldn't you make your strongest point the one that has 3 separate elements they have to meet?
yes, well, I would say that it's all strong. And that while I do believe foreseeability is extremely strong, I think proximate is very closely linked to it, very strong as well. Whichever the court would like to focus on. And while there's an exception that 1 and 3 may be relaxed, if the second is strong, we submit that we didn't know the person, didn't know it was a sale, and in conclusion, with the first 2 elements lacking of foreseeability and proximability, we believe that it would not be just and reasonable.